Wichita Liberty TV, featuring host Bob Weeks. Local politics without the spin. Interviews with nationally respected economists. Hear directly from Kansas conservatives about what matters to you. It's individual liberty, limited government, and free markets. Wichita Liberty TV.
Welcome to Wichita Liberty TV. I'm Bob Weeks. Keen Umbehr was a trash man for 17 years before deciding to sell his business and return to college. After graduating with honors from Kansas State University, Keen enrolled in Washburn University School of Law in Topeka, graduating in 2005. While Keen was operating his trash business in Alma, that's in Waubonsee County, just west of Topeka, he also wrote a weekly newspaper column called My Perspective, where he often criticized the local county commissioners. After the commissioners terminated Keen's 10-year contract, despite the fact that he had never missed a day, Keen filed a lawsuit alleging that the termination was in retaliation for his decision to exercise his First Amendment rights. That case wound its way through every level of the legal system, ending up at the United States Supreme Court. And Keen Umbehr won. In 1996, the Supreme Court handed down a 7-2 ruling in Keen's favor, establishing First Amendment rights for private contractors throughout the country. In 2014, Keen took time off from his law practice in Alma to campaign for the Kansas governorship as the Libertarian Party candidate. Now, Keen Umbehr. Well, Keen Umbehr, welcome to Wichita Liberty TV.
Well, thank you for having me, Bob. I appreciate it.
So earlier today, you and I attended a meeting of the Wichita Pachyderm Club. The speaker was a young man, well, younger than us anyway. His name is Floyd Bledsoe. He served a long term. He was sentenced to life in prison in Kansas for a murder, first-degree murder, that he did not commit. 15 years later, finally, justice was done, I should say, and he was released from prison. So what went wrong in this case? How did he languish in prison for 15 years when he shouldn't have been there to begin with?
Well, in answering the what went wrong question, you look at the whole case in its totality, and you see failures at each level of the court. And so I think the only way you could properly judge what went wrong is a systemic failure of the entire system.
So it wasn't just one person or one slip up in a lab or something. It was really was it a conspiracy or just kind of the momentum of the way things are? Well,
a conspiracy is probably the wrong word for it. We have a process of justice, and it's really the wrong word, Bob. Justice doesn't mean that the right thing happens or the fair thing happens. Justice is the end of a process. Good or bad, right or wrong, guilty or not guilty, doesn't really make any difference. You got this process, and there's been such a reluctance to change the process. The first failure in the Bledsoe case was when Judge Knapsinger refused to give him a directed verdict. Judge heard all the evidence, and there wasn't enough evidence to convict him, but rather than bear the burden a district judge has, he decided to relinquish that, and so that's a failure. And then the next...
So a directed verdict, if I could back up, and I know this just from watching every episode of Law and Order 4 or 5 times, is when a judge looks at the evidence and says, even if all that's true, that still doesn't prove his guilt.
That's right. It doesn't rise to the level of beyond reasonable doubt.
And the judge could have done that, but he did not. He let the jury decide.
Let the jury decide. And that's really an acquiescence of his responsibilities, because as judge, he is the neutral and detached person that when he's hearing both sides and says, well, like, for example, there was this one employment law case. The plaintiffs got up and gave their case, and the judge just did a directed verdict right there. The defense already had all their witnesses, said, there's not enough here. Even if everything you said is true, it doesn't rise to the level of preponderance.
And that's something I think a lot of people don't realize. The defense does not have the burden of proof. It's the prosecution that has the burden of proof. The defense simply has to say, no, that's not enough, or here's something that's contrary to that.
Right. And in a murder case, what we find is the juries want to have somebody responsible. And because they have this feeling that somebody's got to be responsible, and you're sitting over there in an orange jumpsuit, you're going to be found guilty.
And I think Floyd talked about that. He said that maybe the jurors didn't really know if it was Floyd that did this or his brother, Tom, I believe, who actually was the perpetrator here. Didn't Floyd say the jury felt like they had to hold somebody responsible, and here was a guy that they watched, for a while, and he was as good as anybody, I guess.
Right, because, and I don't want to paint with too wide a brush, but the police arrested him, the judge bound him over, so therefore those two groups of people can't be wrong, so therefore we want to find somebody guilty, and whether it was him or his brother, which should be reasonable doubt at that point, they're going to close their eyes and hope and pray they're doing the right thing, because they want justice for this little girl that got murdered.
And so now Floyd is free, and I believe he said, well, what sort of recourse does a wrongfully convicted person in Kansas have to, of course, I imagine a lot of them are saying, thank God I'm free, first of all, but is there any other recourse that they have to try to get back compensation or anything for all the years that they've lost?
Unfortunately, you have to file a civil lawsuit. And, it's some of the people like Kevin Lowry up in Manhattan was incarcerated for 11 years on a rape he didn't commit, served his time, came back, found the evidence, proved that he was not guilty. The judge ruled him that way and sued the state of Kansas, I think, for 12, and they settled at $9 million. And although that's good, I think Floyd Bledsoe needs to sue the state of Kansas for $100 million, because it's only by the pain of a magnificent civil judgment against the state of Kansas will they change this process that they are so in love with. And when we change the process, then we take out, we amend those things that keep giving these wrongful convictions.
Yeah, and really the sting of paying that judgment by the taxpayers, I guess that should get them all worked up and to hold our officials more accountable. Well, as you probably know, I'm not in favor of the death penalty in Kansas. What if Floyd had been sentenced to the death penalty? What might have happened by now?
Well, he would have been dead. If he was in Texas, he'd definitely been dead. There would be no justice in this case, because he would have died an innocent man and nobody would ever look at it again. Yeah. And that is the largest tragedy. Justice could not have been done once the death penalty has been. And
I guess as bad as things have been for him, at least he does have, he's only about 40 years old, I think, so hopefully he'll have a long and fruitful life, but still, it's not good. I mean, not good. It's terrible that what happened to him. So let's hold on to that thought for a moment, Keen, and let's take a moment off for a commercial break here on Wichita Liberty TV. Well, welcome back to Wichita Liberty TV. I'm Bob Weeks, and with me this week, Keen Umbehr. Now, it seems that in most parts of the country, criminal prosecutions are either conducted by or managed by an elected official, very commonly known as the district attorney. A lot of these people, not all, they're politically ambitious. They want another higher office, and they see the DA's job as a stepping stone. If they can get high-profile convictions, then their name's going to be in the paper, on the front page, their picture and everything. Is there a conflict between that motivation and what prosecutors should be doing, which is to seek the truth and justice?
Well, absolutely. The DA is always a political position, always an elected position, and if they can get convictions on difficult cases or high-profile cases, it sets them up for the next elected office, a state office like a Attorney General or Governor or Secretary of State, or even the federal congressional offices. And that's the track a lot of those prosecutors go. So yes, I think there is a conflict there.
And if they really foul up and let someone, or fail to get a conviction of someone who really did commit a serious crime, a serial killer or something, that's bad for them. Well, it's bad for us too. I mean, guilty people should be convicted, people who are dangerous. I think that you, in your personal life as an attorney, are involved in a case about Dana Chandler. And I know that name, but that's about all I know about that case.
Well, Dana Chandler was convicted in 2012 of a double homicide that actually occurred in 2002.
So 10 years later, right?
9.5 years later, yes. And she was living in Denver at the time, and the murders occurred in July 7, 2002, and the case went dead for all that time until 2009, 48 hours at the behest of the county attorney, Chadwick Taylor, gave them crime scene information and crime scene photos in order to produce a 48 hours mystery show that was totally prejudicial to Dana Chandler.
Now, so that's Chad Taylor, who was district attorney in Shawnee County, Topeka, and did he have political ambitions too?
Well, yes, he ran for Senator Pat Roberts' position just in this last cycle.
I thought I knew
and then
the name
withdrew kind of under auspicious circumstances.
So, and what's happened with that case, or what's wrong with it, I guess?
Well, what's wrong with it is, I guess we have to see, if we use what the Supreme Court had oral arguments this January 27th, you can go to the Kansas Supreme Court website and watch the video. But she got convicted in 2012, and this is her first appeal. And the justices were, well, the opening question was to the state prosecutor, Jackie Spradling, what are we to do with all these examples of prosecutorial misconduct you commit in this trial? And they actually, I don't know how else you say it, filleted the state prosecutor for saying things to the jury that absolutely were not true. Material things, like Jackie said, a year before the killings, one of the victims got a protection from abuse order against Dana. The judge, a Supreme Court judge, I think it was Biles, asked, where do we find that in the record? And she says, well, if you're going to limit me to the record, it's not there. And he says, how do you get away with saying something that's not true to the juries with regards to a major material point in this case?
And then not having it be in the official record.
It didn't happen. There never was a PFA. She made it up.
So it sounds like this is a serious case of prosecutorial misconduct. Is that what we would call it?
Absolutely.
And is it purposeful on the part of the prosecutor, do you think, or just sloppy work, or what's the cause or reason, do you think?
Well, I think it's ambition. It's unbridled ambition, because this was a big case. 48 hours. CBS has done 3 shows on this. Other TV shows have done segments on this. It was a horrendous case. And there is no physical evidence. They couldn't prove Dana was ever in Kansas or Shawnee County or Topeka or at the crime scene at the time of the murder. There's arm hair, head hair, DNA, and fingerprints at the crime scene that don't belong to 2 victims and don't belong to Dana, but they belong to somebody else. And the key piece of evidence that the defense got a week before the trial, they've had it for 10 years, 6 weeks before the trial, there was an arm hair that was attached to the hot shell casing at the time of the killings. They had that hair the whole 10 years. Well, anyways, 6 weeks before trial, they decide they're going to test it. They get a mitochondrial DNA test, and it excludes Dana, excludes the 2 victims, but it belongs, obviously the arm hair belongs to the killer. But despite no physical evidence, they convicted Dana on the basis that it had to be the ex-wife, and there was a custody dispute going on, and they theorized that because Mike was going to get remarried to another woman, that Dana went into a homicidal rage and committed the killings.
So what is the status of this case right now?
We are waiting on a decision.
From the Kansas Supreme Court?
From the Kansas Supreme Court. Today, we're coming down to Wichita at 9:30. Everybody's life stops and we watch, because that's when the decisions come down from the Supreme Court. And the Supreme Court, I think, handed down 10 decisions today, but hers was one of them. We're hoping for reverse, remand, vacate. That means she walks out of jail. Reverse,
vacate,
remand.
Or I'm sorry, all 3 of those things together mean she's a free person now.
Free person. A reverse and remand says she's going to stay incarcerated, but she's going to get a new trial.
And a new trial means expense and still jeopardy, right?
Oh, absolutely. Absolutely.
Could be convicted again. So.
But I don't doubt it, because all the lies that the House of Cards that the prosecution built can't be used again.
can the Supreme Court sanction this prosecutor if they really feel that there's been misconduct?
Yes, they could order her to self-report to the disciplinarian, because if I tell something that's not true in my closing, I would have an ethical violation. Mm-hmm. And the same should be true for the prosecution. They should not have any other rule for them.
And these disciplinary actions can be mild or they can be severe, such as disbarment, or is it even a criminal act, perhaps, to lie like that she could actually be found guilty of a crime, a prosecutor, or...
No, only the witnesses take an oath to tell the truth. Mm-hmm. And once you take an oath to tell the truth, you can be prosecuted for perjury if you make a statement that's materially false.
I see.
But attorneys, both the prosecution and defense, they don't take any oath.
Well, it happened on Law & Order, but of course that's a fictitious show, not real life. So anyway, Keen, we've got to take another moment off for a commercial break. We'll be back with more Wichita Liberty TV in just a moment. Welcome back to Wichita Liberty TV. I'm Bob Weeks, and with me here this week, Keen Umbehr. Okay, Keen, in the introduction I kind of laid out I guess it was probably not the biggest thing in your life. I suppose your children and your marriage was that, but you had a business in Wabaunsee County, just east or west of Topeka. You had a major contract with the county. You started writing newspaper columns that were critical of the county government, and they dismissed your contract. And that case ended up in the United States Supreme Court with you as a victor. Now, down here in Sedgwick County, we've got something where County Commissioner Jim Howell, who's only been on the commission a year, now he's the chair. He'd been in the House of Representatives for a number of terms before that. He told the Wichita Eagle this about a company that's a subcontractor to a county contract. He said, if they're working with us as our partners, I want their support across the board. And if anybody's been involved in a negative campaign against us, I would rather not do business with them. And the firm's been removed. Is that similar to what happened to you?
Well, it's almost scarily right on point. The Supreme Court case, you can Google 518 U.S. 668. It's Umbehr versus Board of County Commissioners, Wabaunsee County, Kansas. And the question is whether and to what extent independent contractors can be retaliated by the government. And the answer to that question is no, they can't. Mm-hmm. And so what Mr. Howell did, he promoted a patronage policy there that has, since our case came down in 1996, has been dead. Patronage is dead. And so patronage is, I only want Republicans working for me if I'm Republicans, or I only want Democrats working for me if I'm Democrat. And if there are the members of the opposite party working for me, I'm going to fire them or terminate them, or even non-renewal of them. And so I think this case is right on point, and I would caution that government agency to be very wary, because this is going to turn into a 518 U.S.C. Section 1983 lawsuit, a civil rights lawsuit, because you cannot be denied the contract, denied business, or fired, or terminated, or refusal to renew based on political affiliation or the content of your speech on a matter of public concern.
So your case, you said, was decided in 1996 at the United States Supreme Court. What made you, it was a trash collection business that you have, small businessman in a pretty small Kansas county, I think. What made you stick with it all the way to the United States Supreme Court?
Well, for whatever reason, I'm burdened with a sense of that right is right, wrong is wrong, and government officials have to obey the law. And in my county, I had a contract with the county commissioners, and I would attend the county commissioners' meetings, and I would write articles critical of their actions. And I thought that's exactly what the First Amendment protected. Well, it does, but you still have to fight for your rights. They terminated the contract. And when we terminate, we filed this 42 U.S.C. Section 1983 lawsuit. We lose our first trip into district court. We appeal it out to the 10th Circuit Court out in Denver, where they unanimously reversed. They give the boy a trial. And then it was the county that actually applied for cert to the U.S. Supreme Court. Oh. And they picked it up. 8,000 cases a year appealed for cert, and they only take about 1% of them. So, so we were quite surprised. We ended up winning up at the Supreme Court 7-2. Sandra Day O'Connor wrote the opinion, and basically the import of the decision is you cannot fire independent contractors because the content of their speech on a matter of public concern. So if somebody is supporting another candidate, that's a matter of public concern, that's their political right, and there can be no adverse action taken against that individual for that reason.
And since then, I think that inspired you to go to college maybe and then become a lawyer. And 2 years ago, you ran for governor of Kansas on the Libertarian Party ticket. What did you learn from that, big foray into politics?
It was a great experience. I love campaigning. I'd rather campaign than do anything else. I was a Republican, and I wanted to get out the fair tax message. I'm a fair taxer. And so
fair tax is where we have, instead of income taxes, we have a consumption-based tax, sales taxes.
Exactly right. And I firmly believe that because our current system isn't working. And so I would not get past the primary if I ran as Republican, so I changed my political designation to Libertarian, and I ran there. And I only got into one debate in Johnson County. All the other debates I was excluded, but that's what a third-party candidate has to bear up under the strain. We had a great time. I appreciate what Mr. Brownback. My interaction with him during the campaign. I especially appreciate Paul Davis, very nice man. We just three individuals that had a totally different view of how state government should be run and, in this case, taxed.
Yeah, and I know you've been keeping up with state government since then. I happened to run into you in the gallery of the Kansas House about a year ago from now, and we talked for a while. Any future plans for political office, do you think, in your future? Or
well, in all honesty, absolutely. I'm political. It's my passion. I could never drop it and walk away. I feel burdened with the responsibility that I have to make my world better. And you start locally, and then your state, and then your national. I'm cut out for politics. I love it. I've been defeated a lot. I've had some small victories, but most of mine is in a defeat. But you only learn from your defeats. But I have to admit, you meet a lot of great people.
Well, I think you've done a lot. I mean, your case in the Supreme Court, is that cited by other courts as precedent? And so
Yeah.
you said you really made new law, or at least got the law to be thought of in the correct way, I guess, for the whole country there. And then also I know many people know that your running mate for governor was your son, Josh, who's
Right.
a physician here in Wichita, and is really blazing forward a new trail in the way that doctors deliver medical care. So yeah, you've done a lot for our state, Keen, and I appreciate you stopping by, and we are out of time. So
Well,
I appreciate you coming by today, Keen, and good luck to you in the future. So
Thank you.
that's all again for this week of Wichita Liberty TV. I'm Bob Weeks.